3, 2,
Okay guys, welcome once again to another episode of Scott Talks Law. So this is an episode whereby Scott talks law. And in this episode we are going to talk about the tort of nuisance. So we are going to talk about the definition of nuisance, the essential elements under the law, tort of nuisance, the types of nuisance, the public and private nuisance, the remedies and the defenses in the tort of nuisance. So in defining nuisance, nuisance is derived from a Latin word which is nuia, and it means the act of causing annoyance, disturbance or interference to someone. So nuisance as a tort means the unlawful act of interference with the right of someone in a particular piece of land. So you are causing interference or you are denying, limiting or interfering with this person's right in that piece of land, then you are committing nuisance against that person. So you need to understand that there is some relationship between nuisance and trespass. And as I said earlier on in my earlier episode, that trespass is the unlawful presence in someone's piece of land, body, if that is battery, and property or chattels. Unlawful presence. So trespass is also unlawful interference, but the distinction is that trespass is direct, whereas nuisance is indirect interference. And another distinction is that trespass is auctionable per se, and nuisance is not auctionable per se. You need not to show damages after that act has been committed. Damages in trespass are not required, just auctionable per se. But under nuisance, that is one of the essential elements, that damages must be proved for an act to constitute trespass. So there are examples of things that can constitute nuisance, or things that causes nuisance. So things like noise, things like pollutants, like gases, bad smell, and smokes are examples of things that cause nuisance. So if these things are emitted, or these things cause interference to someone, or they limit someone's enjoyment of right, then that act of nuisance has been committed. So we have the essential elements under nuisance, and there are two essential elements. The first element is the unlawful act. That act must be committed, and this act must be prima facie unlawful for it to constitute as an element of nuisance. You must show that how this act was unlawful, how it breached particular statutes or laws that were there for it to be unlawful. The second element is the damages. As a result of that act, some damages happened. As a result of that act of nuisance, the damages that were caused must also be shown. The unlawful acts and the damages, they are the two essential elements. So there's this case of Hasley versus Esco Petroleum Company Limited. So this is a case whereby someone established a company that produced pollutants that affected the defendant's health. So the defendant was affected as a result of that company, the noise and that dust that was produced. It was a cement factory. So this person who is claiming for to be compensated for nuisance must show that that unlawful act was committed and that act was unlawful, and the damages that resulted. So this person incurred health issues from that company. So those things must be brought out. So examples of incidents or scenarios where nuisance can be established is whereby you establish a factory that emits pollutants or poisonous gases that affects people's health, or maybe you establish a factory, a limestone factory, and this factory emits dust and gases that affect people. So the neighboring people who neighbor that place can sue for acts of nuisance if they are affected from that factory. So there are types of nuisance. Another scenario is whereby you have a herd of cattle, and this herd of cattle escape and maybe they go to the road where they hinder transportation or they hinder movement. So that is act of nuisance to public. It's called public nuisance. You are affecting the public. The public cannot move. They cannot continue the usual activity. Their rights are limited. It's a result of your action. And you know the road is not meant for animals. It's made for people and vehicles and people to pass. So you are committing nuisance. If the public sues you, then you are committing nuisance to the public. So there are types of nuisance. There are two types of nuisance. You have the public nuisance and the private nuisance. Public nuisance is that nuisance that affects the public. It affects the public morals, the public general, and the one to sue. The public is the one that will sue you. You are affecting the public. And private nuisance is that nuisance that affects private individuals. So it's those private individuals that are supposed to sue. For example, if you have a neighbor and you have this habit of listening to high volume music. So if you have those, you are affecting your neighbor. If your neighbor maybe has children who are learned or are learning, they are not able to concentrate in their learning. Maybe they have assignments to do. You are not supposed to listen to high volume music. So if you do so, you are committing nuisance or you are interfering with your neighbor. So that act is nuisance. And if your neighbor sues you, then you will be liable for committing nuisance. So private nuisance occurs within private individuals, and especially it occurs between neighbors. So you are just supposed to observe that neighbor principle. So those are the two types of nuisance, the public and private nuisance. So we have the remedies under nuisance. There are many remedies, but we are going to talk about those remedies that we will be able to capture. So we have injunctions. We have permanent and public. We have private and public, permanent and temporary injunctions. In order to stop that act of nuisance can be directed by the court against that person who is committing nuisance. Another remedy is damages. We can have nominal damages according to the act that was committed. We can also have statutory damages, those ones that are prescribed by particular statutes in relation to that act of nuisance. And you can also have those exemplary damages or punitive damages to punish the wrongdoer so that he cannot commit that act again. Those are just punitive damages to stop that person from doing that or committing that act of nuisance. So we also have the defenses that someone might raise. First defense is statutory authority. If that act of nuisance has been prescribed by a particular statute, then it qualifies to be a defense for nuisance. Another defense is that one of the defense of prescription. If that particular act has been prescribed, and this occurs whereby that act was allowed or permitted for a particular period of time. So if that act of nuisance has been occurring for like 20 years without an action being raised, then you cannot raise that act of nuisance after 20 years because it had been prescribed. So after the elapse of 20 years, you cannot bring an act of nuisance for an act that has been prescribed or allowed by law to operate. And there is a case here that we are going to. Under prescription, there is this case of Strange versus Bridgman, an 1879 case whereby someone was operating a confectionery factory. And this factory had lasted around 20 years, for like 20 years. So there's this physician who came and established a consulting room after that factory had been operating for like 20 years. So this physician went and sued for interference or disturbance caused by this factory. So the court could not rule in favor of him because this act had been prescribed by law to operate and it had lasted for 20 years. So you cannot bring an act of nuisance after the prescribed time. So the prescribed time there was 20 years. After 20 years, an act of nuisance was not allowed or permitted. So the defenses for nuisance are prescription, and statutory authority. Contributory negligence can also be a defense, but I'm not sure about it. So another remedy for nuisance that I didn't mention is abatement. And abatement, this is whereby the court allows the affected party to remove the act that causes nuisance without considering the law. The law is not considered. That act is commanded to be removed, that act that causes nuisance. If it is noise, those people are, that noise is removed, or the factory that causes noise is removed under abatement. So I think that is the end of my lecture about nuisance, and just stay in touch for more episodes that will come later on.